What's the Church of Scientology so afraid of?
This is SPTV.
Oh, I forgot our little name tags. Gosh darn it. Aaron done messed up. All right. Welcome, everyone. Welcome, welcome, welcome. I'm here with my lawyer friend, Zach Morgan. Look, I even forgot to pull up your YouTube channel. Tell people to subscribe to you. Gosh, diggity darn it. Apologies for my language, everybody. But all right, if you're not already familiar with Zach, look him up on YouTube. His channel is called Your Lawyer Friend, Zach Morgan. Zach, I'm hoping you can set me straight on all this Danny Masterson appeals stuff.
I'll do my best.
All right. Well, thank goodness someone's got to set me straight. Okay. So let's recap a little bit. So Danny Masterson and his team had 60 days from September 7th to file their appeal.
Correct.
A couple days after the sentencing, they informed Judge Almeida, who was the presiding judge over the second criminal trial, that they would be filing an appeal. But it took them almost the entire 60 days to file the paperwork with the second appellate district. And then when they filed the paperwork, instead of filing the appeal, they said, oh, can we have 45 more days? And then the judge granted that. First of all, does any of that strike you as unusual so far?
No, that's super common. You had mentioned in another video that initially they filed what's called a notice of intent to appeal. Basically puts the court staff on notice, make sure these records are available and secure. At some point, they're gonna be ordered to the appellate court. Then that's part of that initial notification. The 60 days runs, and then they file the notice of intent to appeal. Then that's when the calendar starts, or however it works. And then they run up to the deadline. They have prepared as much as they can, but they're not done writing the argument, so they ask for more time. And in that pleading, it probably said something like, we've already written this much, but we're still waiting on this particular information, and we're working on this argument, and we need more time. The judge is going to say, sure, no problem. That's a super common request. Now, if every time you're trying to file something, you need more time, eventually judge says no. But 1 or 2 extensions of time as a matter of due course is super common.
Okay, good. And I know this isn't a big deal, but it just sticks in my brain. When you look in the case record, the request for additional time and the granting of additional time are both filed on the same day. How's that even possible? No hearing, no nothing?
Yeah. So these procedural matters like this, basically they give the state notice, hey, we're requesting more time. And if the state says, sure, we agree, no problem, then it just moves on as a matter of due course.
I got it. Okay. Now, the second issue. At Danny's sentencing, there were 2 high-powered appellate specialist attorneys present at the sentencing who spoke, Benjamin L. Coleman and Alan S. Yokelson. And Sean Hawley even made reference to the high-powered appellate team in some of the press that she did immediately after the sentencing. In all of the paperwork filed with the second appellate district so far, Phillip Cohen is still the attorney of record. No, I've been having a little bit of fun speculating that Danny can't afford to hire the appellate specialist, but we don't know if that's true. What should anyone make of the fact that the lead defense attorney for Masterson's defense team is still the attorney of record for the appeals?
For the purposes of going and setting those timelines, filing of the notice of the intent to appeal, filing for the extension of time, somebody has to do that. The appellate specialists are specialists probably in writing arguments. So they're writing the arguments. When the arguments are prepared, I fully expect Cohen will ask the court to withdraw from representing the defendant. The court will grant that. These other attorneys, if they haven't already, will file their entry of appearance. And essentially the system is set up so that the defendant doesn't go unrepresented at any point. So when the appellate attorneys come in, that's when the trial counsel can leave. However, if one of the grounds for defense is inadequate representation of counsel, the trial counsel can't handle that. They're like, ethically, they can't take that issue up on appeal.
If Danny was going to argue inadequate representation of counsel, and by the way, some people in live chat are saying they can't hear me. There's nothing wrong with my audio from what I can see. So please let me know if you guys can hear me okay. If he was going to be arguing that, there's actually 2 different realms or whatever that he could potentially argue inadequate representation. It's hard for me to imagine arguing that Phillip Cohen and Sean Hawley didn't adequately represent him. That would be very hard to believe.
So now, before I think I know where you're going, but I wanted to address that real quick. That argument is offered as a matter of due course. You could have the best defense team ever, but they're going to argue it anyway. Because if you don't argue it, if you don't ask for the relief, you can't get it. They're going to ask for it. They're not going to get it, but they're going to ask for it because that's what they're getting paid to do.
But if they were going to ask for that, would Phillip Cohen really be sticking around filing paperwork with the appeals appellate division, or am I overthinking
at this point, probably? But again, when the argument is submitted and then it gets set for oral argument, if any, he'll be long gone by then. He's just doing sort of the administrative paperwork and making sure that the dates get calendared correctly, preserving the record. He's doing sort of the administrative cleanup part. He's not writing, if they're challenging the conviction on ineffective assistance of counsel, he's not going to be doing the bulk of the argument, if any at all. He probably won't be involved at that point.
Okay. Now, Thomas Mesereau was Danny Masterson's first attorney. I think it was Thomas Mesereau and Sharon Applebaum. And he represented Danny during the pre-trial hearing. And he made some very big mistakes that Danny's team was stuck with dealing with. And he was fired shortly thereafter. He's the one who introduced the Scientology ethics book into evidence based on some questions that he very carelessly asked. I think it was Jane Doe 3. The attorneys, Danny's defense team in the first trial and the second trial, repeatedly complained to the judge that they were having to deal with fallout from the mistakes made by Thomas Mesereau, who had been long since fired. If Danny's going to make an inadequate representation of counsel claim, could he try to make that claim for both Phillip Cohen and Sean Hawley and Thomas Mesereau, or does he have to pick?
No, it would be all done under the same argument. Like, the issue, they're called issues on appeal. Issue number one, ineffective assistance of counsel. Here's all the things Cohen and his team did wrong. Here's all the things Mesereau and his team did wrong. And the appellate panel can agree with some and disagree with some. They sort of have discretion there. I don't know that challenging Mesereau's representation is going to be a winning argument, because at the preliminary hearing, all the pre-trial stuff, the rules of evidence don't really govern those, because there's no jury. The rules of evidence apply when there's a jury. And so the fact that this book gets introduced, when it goes to trial, the trial team did, in this case, I believe, object to the admission of this book or excerpts from it or whatever. The judge is actually going to make an independent evidentiary analysis and make a ruling based on the rules of evidence at that time, based on that book, for the purpose they're seeking to admit it. And so even though it would have been used in 15 other hearings, its evidentiary value is evaluated at trial independently of anything that's happened before.
Very interesting. Okay. Okay. Set me straight on the rules governing when a lawyer can and cannot get rid of a client. And let me frame this a little bit, because someone mentioned in the comments of my video yesterday, the handle is The Maleficent One. It says, FYI, I'm sorry, I'm jumping around a little bit on this.
Sure.
Yesterday in my video, I speculated, I was having a little bit of fun, to be honest, that maybe Danny can't afford to hire the appellate specialists. And so Phillip Cohen is stuck with him because Phillip Cohen can't drop a client due to non-payment. I mean, honestly, I'm just having a little bit of fun trolling a little bit. But the comment said, FYI, a trial attorney cannot be forced to stay on as their client's lawyer for the appeal unless that is specifically outlined in their original retainer agreement. That never happens. I'm sure your lawyer friend will explain that to you. Will you explain it to me?
Sure, I will. So the premise, I think the commenter is getting at, is accurate at about a 10,000 foot level. There's some nuances here that I disagree with them with, but the premise is generally correct. The attorney-client relationship is the scope of it is defined by the retainer agreement. I'll do everything but go to trial. I'll do everything but the appeal. I will get you through preliminary hearing and try to negotiate a plea agreement, whatever. Right. The scope, and also, are you paying me hourly? Is it a flat fee? If I'm taking all the way to trial, X is due before the preliminary hearing, X is due before trial, and X is due at jury verdict, whatever, or hourly, however, that's all set forth. If the agreement says I'm going to take it all the way through appeal, the attorney is contractually bound because they've been paid for that. But if I decide that you're just a terrible client, I don't want to represent you anymore, I have the right to withdraw my representation. And if I ask the judge, I want permission to not represent this person, I may have an ethical and legal obligation to refund you some of your money, because you possibly paid for services not rendered. So I can refund some of that money. But once an attorney has entered their appearance, like literally you've seen them in the court filings, entry of appearance, the name of a document, that's the lawyer's formal notice to the court. I represent this person. Once that entry of appearance is on file, the attorney cannot just arbitrarily stop representing that client. They have to go to the court, file a motion to withdraw. And most of the time it'll say you have to state that you want to withdraw. The grounds for withdrawal can be, the client's failed to make payments. I don't do appellate work. Client has retained a separate counsel to do the appeal, whatever. Then you have to list any hearings that are pending. And then you have to identify whether or not you've notified the client. And so generally speaking, if you don't have anybody lined up to handle the next phase, the judge is going to say, no, I'm going to give you 30 days to help the client find somebody else. After 30 days or whatever arbitrary time frame, I'm going to let you withdraw, but we're not going to let the client stay high-centered without help. You're going to help the client try and find an attorney. If they're just a dick and don't want to find somebody, that's their problem, but you're going to have to help them in good faith. If they want to drown themselves, that's fine, but we're going to give them a life vest. Whether they put it on is their problem.
Right. So going back to the comment, and to be fair now, this person was just saying that Phillip Cohen can't be forced to stay on as Danny's attorney unless it was specifically outlined in their retainer agreement. I guess where I continue to be a little bit confused is why would Cohen, let's just pretend he's not being forced to.
Sure, I hear you.
Why would Cohen even want to stick around and be a paper pusher or a motion filer at this point? Why wouldn't he? Like, what he was hired for is done. Now they're working on the appeal. Why would Cohen even want to continue to be around to put his name on filings? I don't get it.
You're not the only one that doesn't get it. I inherently don't get it either. Again, like I said, I think he's just doing some cleanup work sort of at the end of the case while the appellate counsel transition into the active role. I don't foresee he's going to be around a long time, but it could also be that he may be the lead attorney, and let's say they're not going to raise ineffective assistance of counsel issues. So he stays on the case. He went out with the client's consent and permission and hired appellate specialists. I'm still going to be the face of the case, but I've hired people smarter than me to take care of this issue. And so he shows up to court, the judge takes roll. He says, I'm here. And so are the appellate attorneys. When it's time to present the argument, he's going to say, I'm going to ask my co-counsel, Mr. Smith, to present argument today. And so he's just delegating that task to another attorney. That could also be what's happening.
Interesting. I do feel that probably no one truly understands all the ins and outs, the nooks and crannies, and the nuances of this case better than Phillip Cohen at this point.
Probably.
And if they're not making an inadequate representation of counsel argument, then I think it does make sense to keep Phillip Cohen on. Because I mean, guy, even if you're the world's best appellate specialist coming into a case like this and being expected to truly understand everything that's happened from the beginning, I don't know. I don't care how smart you are. That seems like a tall order.
Yeah, it is. There's a lot of moving pieces here. And a lot of times if outside counsel is brought in to do appeals and the lead trial counsel decides to either take a secondary role or even leave the trial altogether. I know a lot of trial attorneys will try it to a jury when it's time for appeal. That's not what we do. We're going to go get another case. They will often prepare really extensive briefing memos. Here's the legal issues. Here's the evidence we have. And they'll sort of organize it. And then they'll hand all of that off to the appellate counsel and let the appellate attorneys do their thing. But you don't just hand it off and say, here's the file banker's boxes. Good luck. There's normally a transition period, meetings, briefing memos. There's an entire dissemination of information before one attorney leaves and the second attorney takes the file.
That makes sense. Okay. So the judge has given a deadline. I believe it's December 22nd for the appeal to be filed. So what is the proper legal language? Like, it's not considered a complaint or a First Amendment complaint or anything like in a civil case. What is that document where your actual argument for the grounds of the appeal? What is it called? It
depends on the jurisdiction. In most places, they'll name it something like the appellant, the person appealing, the appellant's brief in chief, and issues or in the raising of issues. And basically, at the very beginning, they list, here's the 15 things we think the trial court did wrong. Then underneath it, the next 50 pages is all the arguing those 15 issues. But they say up front, here's the things we're alleging they did wrong. The rest of it is, and so it's actually, the term would be a petition in error. We're filing the petition, raising questions of whether the judge committed legal error in ruling on certain issues in this case. Here's what those issues are. And then we then we write the written argument underneath. So in most jurisdictions, it's called a petition in error.
Interesting. And just because the judge has given them until December 22nd, in your experience, do they always wait until 2 days before the deadline, or they could file next week for all we know?
Yeah, that 45 days or however long it is just gives them enough time to figure. If they're finished tomorrow, they file it tomorrow. I suspect they're going to take most of the time, especially if you've got somebody who is able to pay a fairly substantial legal bill. And I'm not picking on those folks. That just means they can afford to have every attorney in the firm look at it. If I'm writing an appellate motion, I might even bring my real estate contract attorney in just to look at it for style, for words, for spellings. You don't practice trial law. Does this make sense when you look at it? Could we be more concise? Could we be more articulate? To me, it makes perfect sense because I'm the one writing it and I know the facts. I may have an attorney in the firm who, writes contracts and real estate closing documents for a living, have them look at this thing, have them bill their time to the file, look at it, review it, and say, hey, I think you can clean this argument up because I'm a lawyer and it doesn't make sense to me.
No reason not to take every hour.
Yeah, use every resource available. Yeah.
Okay, so one of the reasons I'm trolling Danny a little bit for maybe not being able to pay for his attorneys is because of what Jeff Augustine reported on the Scientology Money Project blog about Danny getting hit with the IRS with $128,000 tax lien.
Correct.
Now, you and I spoke very briefly about this before we went on camera about the implications of this. And my question to you basically was, would it be incorrect to infer that this tax lien means Danny's broke or he can't come up with the money to pay the taxes, or what? And how do you see it?
So a tax lien can occur can be assessed and put on a property for any number of reasons. The most common is failure to pay taxes. Because remember, it is not a crime to not pay; it's a crime to not file. As long as he filed his taxes but didn't pay him, he hasn't violated the criminal law. He's violated the civil law. So they file a lien on the property. Even if he's on a payment plan, they'll put a lien on the property till he pays that lien off in full. Because that's the government's only recourse if he stops paying, is they just go foreclose the lien. And if you think about it as a homeowner with a mortgage, even if you're making your mortgage payment monthly and you've never missed a payment, they don't release the lien off your property until you make your last mortgage payment. Because if you do default, the only recourse they have is to foreclose on the mortgage.
So I guess what we don't know is, did he just not file and pay taxes for a few years, or did he get audited? They found he owed, and then they hit him with the tax lien. Maybe he entered into a payment plan or something like this.
Yeah.
We just truly perhaps don't know enough.
Yeah, well, we don't know, but I think you are fair in assuming that it's one of those two reasons. If I would assume he actually filed, otherwise the IRS would be prosecuting him criminally for failure to file taxes, tax fraud. I think one of two things, in my opinion, has happened. He filed but didn't pay, or he filed and paid but underwent an audit and failed the audit to the tune of $128,000, and he's on a payment plan to satisfy those obligations. And unless and until those obligations are satisfied, the lien will remain. So I think you're right on track with assuming one of two things probably happened. Those are the two most common reasons that tax liens are assessed to property.
Right. And I know I'm having a little bit of fun, pointing to anecdotal evidence that Danny might be broke. But if he was broke and he couldn't hire these appellate attorneys, would Phillip Cohen just be stuck with him?
Not to a point, but not completely. Like an independent ground to stop representing a client can't be they can't pay their bill. Right? I can't represent this guy because he owes me too much money. The court will say, the judge will say, try to work something out with him, try to work out a payment plan. However, the law is clear that a judge cannot force an attorney to represent a client to the financial detriment of the attorney. Right? This guy's not paying his bill, but you're going to represent him till you're both in the poorhouse. Like, they can't do that. If you can make a hardship showing, I got to make payroll. I got to pay my paralegals. I got to pay my legal assistants, and I can't pay him because this guy's got me so far behind in my ability to make payroll because of this outstanding invoice. And because the time it takes to work this case correctly, I can't take on new cases that are going to pay, and I can make payroll on these other cases. So they can't be forced into a hardship representation, but they do have to show the judge that it is a hardship. If you don't let me out of this, I've got employees who aren't going to be able to feed their families.
Somebody did point out to me in the comments section that, during Danny's trial, he was on like some $3 million bond or something like that. And that once he was sentenced, that bond was released. And so Danny's probably got a few million in the, available. And I said, I think they just put a lien on his house for the bond. That doesn't mean he's now, cash
Correct.
flush.
I would agree with that.
And when they issue the bail bond and they're putting a lien against the house, do they only take into consideration the market value of the house, or do they care how much equity you have in it?
It's a little bit of both. Because if I got $1 million house and I have $1 million bond, but I only put 2% down and just bought it, I only, right, I just not $2 million. But that is that is an analysis the court will do to determine whether or not the bond is sufficient.
I see.
Oh, you want to offer your house as collateral for the bond? Okay, we need certified copies of the land records to make sure that there's no mortgage, or if there is a mortgage, we need to see the most recent mortgage statement to show what your equity in the property is. So that's a very reasonable analysis that the court would do when determining whether or not to bond it.
Right. I've also had some comments that are like, look, the guy might be in prison, but he's still getting some residuals or syndication payments for that 70s show. And my only comment to that is, I'm sure there's some payments, obviously, but they didn't get the exclusive streaming rights picked up the way they were hoping to. That was going to be the real payday. And Danny's been paying lawyers for years and years and years and years.
Mm-hmm.
And I don't know. I wish I had a little more transparency into.
So there may be a back door to get some of this, actually, and that's with the divorce that Bijou Phillips filed. At some point, the parties are going to now. Wealthy individuals in most states, including California, can normally get their financial records sealed, but not always. If for some reason they don't get sealed or don't get sealed immediately, if there's some astute sleuths out there that can catch that before it's sealed, before a protective order is placed on those documents, they generally have to disclose their assets and their liabilities in writing.
Oh, that would be
now, whether it's subject to a protective order immediately or at some point in the future can depend, but there is a possibility that if it's not immediately subject to a protective order, some of those documents may end up in the public domain.
Okay, well, for you internet super sleuths out there, because I do not have the attention span or to go search for these divorce records whenever they appear, wherever they appear. But for any of you guys out there who do want to dedicate yourself to this issue, keep an eye out. And if you find those records, please shoot them over to me at growingupinscientology@gmail.com. Okay, are there any other issues relating to the appeal? I'm just looking over at my notes. Anything else you thought?
So, kind of like I warned people about the Rimini case, the appellate process often takes much longer than the build up to trial. I suspect that. So the workflow is there's the notice of the appeal. Then there's the brief in chief, which is now due December 22nd. The government, the state, the people, I think as they call them in California, will have another 60 days and possibly an extension if necessary to file their brief in response. Then Masterson's team will get to file a reply because they're the ones, right? So they get to answer the government's response called a reply. You have the motion, then you have the response by the state, then you have the reply. And then the determination by the court will be made. Do we want to hear oral argument on this, or are we just going to rule on the pleadings? There's no guarantee you get oral argument. Some courts love to offer oral argument. A lot of federal judges say you're not going to ever see me in person till trial day. I'm just going to write orders. And then a super secret closed door vote will happen. Whether if there's argument, that's after argument. If not, it's after the pleadings are submitted. The judges will read them. They'll deliberate. They'll vote on what to do. And then the drafting process begins. And that takes months of the judges circulating drafts of the opinion back and forth until everybody agrees. Yes, this opinion is correct. Everybody who's going to sign it signs it. Any dissents are written. So this could take 9 months or a year or longer after the judges get it. I mean, if you think about it, the Supreme Court picks up cases in October, here's argument before Christmas, and issues rulings in June. And that's the Supreme Court of the United States with all the assets of the federal government to help them.
Wow. I don't know where I got this from, but someone said expect the process from start to finish to take a couple of years. In your opinion, what's the fastest it could take?
Probably 9 months.
From today,
assuming there's no oral argument, everybody briefs we've got one extension to December, probably August or September. If there's no additional extensions, there's no oral argument, and the brief writing process is quick and efficient, I would say probably September, but I suspect it'll probably be early 2025 before we get an opinion, but I could be wrong.
Wow. Well, keep in mind, folks, if Danny Masterson is ever going to roll over and spill the beans on Scientology and write some tell-all, it will not be before his appeals, his opportunity to appeal has been exhausted. And when that when that appeal process is done, depending on whether Scientology has expelled Danny Masterson or not, we still need written confirmation of this. But if they've expelled him and his appeals process is up, I think we can expect Danny to sing like a songbird. I mean, if it's in his benefit, like, isn't there some rule that a convicted felon like this is not allowed to make money off of their crime, or what? How would you describe it?
Yeah, that's exactly what it is. Criminals cannot profit from their crime while they are incarcerated for that crime. Now, somebody gets out of prison and they write a book after they're released. That's different. They're no longer incarcerated. They've served the sentence that was imposed by the government for the criminal wrongdoing, but you can't make money while you're in prison. What can happen is they can actually, the government will set that aside in a trust account on your behalf, but you're not going to get access to it while you're in prison. And if he's serving in some jurisdictions, if he's serving 30 to life and it's starting to lean towards life, there's a chance that his children could get that money at some point, but there's a very strong likelihood he will never see any profits from anything that he writes.
Well, this is California. So there's a very good chance when Danny becomes eligible for his, I forget what the word for elderly. The feds call it compassionate release. Yes. And I get conflicting emails about this from experts. Once Danny has served 20 years, he will be over 65 years old.
Yeah. So he may be eligible. And I could be wrong. I don't practice in California. I'm hard pressed to believe that it's an absolute rule. At 65, we open the prison doors. Most of the time, the way these generally work is once you reach the minimum threshold, if you become sick, you get cancer, you become a diabetic, or you have, kidney disease or something, and you become an extremely expensive burden medically on the prison system, okay, we're going to release you to the outside where you can get treatment on the outside that we don't have to pay for. But just in most cases, just because you meet the minimum age, if you're otherwise healthy, if he's out doing push-ups and pull-ups and lifting weights every day and he comes out looking like the Hulk and he's in great physical shape, that just because he's 65 doesn't mean they open the prison doors. Most of the time, you have to have a qualifying medical condition to qualify for that release. So there's two qualifications. You have to qualify medically with an illness or a disease, and you have to qualify based on age. That's how it works in the federal system. And the states that have adopted this generally parallel the federal system.
Interesting. Okay, so for a moment, let's throw out the idea of Danny, turning on Scientology, writing a book just for money. Give me your input on this. Some people have shared sentiments with me that, so forget writing a book, forget being public about it.
Sure.
That if Danny were to cooperate with the federal government, even though he's serving state prison time, if he were to cooperate with the federal government in certain investigations or indictments or prosecutions into Scientology, the feds might have a way of making his next 20 to 30 years more comfortable. Do you think there's any truth to that?
I can't imagine that the feds would have anything to do with it. This was a conviction in California state court. So the feds don't actually have jurisdiction over California state court violations, federal California state law violations. If I violate a federal law in California, they do. But if I violate a speeding law in Los Angeles, the U.S. Marshal Service and the Department of Justice has no authority, no jurisdiction over me.
Okay, well, now I'm just getting crazy town speculation wise. Let's say and really, I'm just pulling this out of my butt. Okay,
you're all right. Go ahead.
Let's say the California state attorney or attorney general of California really wants to go after Scientology, but doesn't quite have the ammo to do it. And let's say the feds go to him and be like, "Hey, look, if Danny helps us with X, do you think you might be able to make his time a little more comfortable for the next 20 or 30 years?" I mean, is something like that even possible?
Oh yeah. I mean, anything's possible if they were to work with the California Department AG's office or Department of Justice, whatever they call it. The AG could certainly go to the California governor at any time and say, "Hey, we have this major situation that we're about to solve, but it may require you commuting the Masterson sentence to either time already served, or maybe we take it from 30 to life to 15, and at 15 he's done."
I'm just talking about putting him in a nice, maybe lower security place, a little closer to his family.
Oh yeah, absolutely. Those are all absolutely things that could be done at the AG level. And the extreme of that would be you could even get the governor's office involved and have him commute that to either time served or a lesser sentence, so he's out before he's 70.
You hear that, Danny? You hear that, Danny boy? There's still hope for you. There's still something you can do about it. You can still do the right thing. You should have done it earlier, but never say never. See, to me, that's fascinating because Danny's not going to do 20 years of hard time for Scientology. He's just not. He's just not. He's going to do whatever he can do. Once his appeal process is over. Anyway, that's what I would do. That's what I think he would do.
Bubba the Love Panda is going to be lonely.
Yes, indeed. Okay, last thing I wanted to just throw by you. I'm told that one of the things that's holding up Danny's transfer to his forever home is that, he had registered firearms to himself. And during this whole process, anyway, they're basically waiting for him to prove that these firearms have been sold. They're in the possession of a registered agent. That agent has to either sell them or somehow destroy them. And that literally, this is what's holding it up. They can't officially transfer him until this firearm issue is fully resolved. And if they can't get it resolved in enough time, the DEA is going to or the FTA. No, I'm sorry.
ATF.
ATF, Jesus.
I'll call Tobacco and Firearms.
The ATF will actually raid the address of the place where of who's got his firearms if they can't get.
And if you want to add another level of complexity, technically there's a protective order in the divorce that says nobody can buy or sell anything outside the ordinary family dealings of the business because those firearms are an asset of the marital estate.
Oh, someone's going to get raided. I'm telling you, someone's going to get raided over this. I guess we'll see. We will see. All right. Well, that exhausts all my questions for now, at least. Let's see. There was a question here. Uncle Radley. Question: the statute of limitations was changed after Danny committed his crimes. Why doesn't the ex post facto law apply?
Because the law that was in effect at the time of the wrongdoing is the law that governs the proceeding. The law that was in effect in 2000, and some of this stuff even occurred back in the 90s, but 2001, 2002, whatever, I forget the exact years, but however the law existed at that time is the law that he is tried under. It's actually unconstitutional to try somebody under a law that didn't apply when they committed the wrongdoing. So if they tried to apply the new law to him, the statute of limitations or whatever, that would be unconstitutional. Because you're subject to the law that existed at the time you did the wrongdoing, not what happened after.
There you go. Christian B asks, could Danny be required to pay child support while in prison, allowing Bijou to get any money coming to Danny from his old acting projects?
Not only can he will be required to pay. And when it doesn't, it will be an arrearage. It will also accrue interest. So if he were to ever walk out of prison before he could get a job or a driver's license or anything else, he would have to account for that arrearage and the interest that accrues. So if he were to get a job, they would automatically withhold, the state would intervene and withhold a percentage of his paycheck to satisfy this child support arrearage.
So even, considering that he could have these financial obligations while behind bars, they still would not let him make money on a book and have the money go towards something like this?
Well, they could. He would have to petition for relief. And I saw it in the chat earlier. It's called the Son of Sam law. He could petition for relief. Hey, I want to receive the proceeds from this book, but I will stipulate that you're allowed to intercept those proceeds to satisfy this, as opposed to I want relief and let it just sit in the trust account to accrue that I can access when I get out. Instead, I want the proceeds to flow through, but I'm giving the government permission to step in and intercept those to satisfy financial obligations.
Awesome. That makes a lot of sense. All right, guys, if you are not yet subscribed to Zach Morgan on YouTube, you can find him. The name of his channel is Your Lawyer Friend Zach, spelled Z-A-C. This has been a lot of fun. As soon as I have a few more questions, let's do this again.
We'll do it again. I appreciate everybody.
Thanks for hanging out with us, you guys. Thank you, as always, to everyone who watches until the very end, and we'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not,